Sexual harassment at the workplace. It includes the such unwelcome sexually determined behavior as the physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal account conduct of the sexual nature. There are two key issues in the understanding the concept of sexual harassment at the workplace. The unwelcome lay focus on the woman's perspective. The focus is on how it affects a woman rather than what was the intention of the act. The conduct should be of a sexual nature. For instance, if an employer or the superior discriminates against an employee on the basis of gender and denies her a promotion, but there is no conduct of sexual nature, it will not amount to sexual harassment. This only conduct of a sexual nature comes within the ambit of the direct sexual harassment. The illustration below explain that it is meant by the conduct of a sexual nature. The verbal sexual harassment, asking for demanding sexual favors, making sexual or obscene comments, jokes, proposals, singing obscene songs, discussing, commenting on women's personal issues such as the appearance, marriage, pregnancy, saying something sexually demeaning, or humiliating unwanted phone calls. Quid pro quo sexual favor as a precondition to employment, increment, promotion. This means that a woman would get benefits of being employed to or promoted to get an increment or a raise in grade or academic acknowledgement or recommendation only if she conceded to get harassment. Retaliatory refusal to provide sexual favor results in the backlash against the employer. This could be in the form of giving low marks, failing the student in an academic institution, or deny increment, promotion, and the professional opportunities to the woman in a working environment. Hostile working environment. Workplace environment becomes sexualized to an extent that the employee's ability to work is affected. This is where the perpetrator may not directly harass the woman, but he may put up a gender insensitive poster, insist on the gender insensitive computer screen, display pornography, say lewd jokes loudly, and so on, and which make it extremely uncomfortable for women to work in that environment. At an interview for determining increment and promotion, B, the immediate supervisor of A, started posing questions to A about her sexual history and preferences of the sexual acts. It was implicit that if A did not answer these questions, B would not recommend her for increment or promotion. She found the line of questioning undesirable. B has committed quid pro quo sexual harassment. B, an employer, makes A female employee stay late in the evening at the office on the pretext of the work. Long after all other workers leave the office for the day, he would find excuses to sit near her and suggest that they could go together to watch a film. The principal of a college calls a girl student to his cabin repeatedly, and on the films, he pretexts to discuss studies. In his cabin, he puts up the pornography pictures of women, which make it uncomfortable for A to even step into the cabin. Causes Sexual harassment at the workplace has been a prevailing practice for the decades. In, if not centuries, it became much more prevalent and visible when women stepped out of their homes and took up the jobs in the big numbers. This threatened the male domination and the monopoly in the public sphere, as in government institutions, educational institutions, corporate offices, and so on. Added to this, women have been increasingly viewed as sexual objects and as targets of the sexual acts in the private and the public sphere. Sexual harassment is an act that strikes at the root of the woman's right to life with dignity and to travel, function, live, study, work in a safe environment that is free of sexual harassment. Though sexual harassment of women and girls is rampant in many places, such as public roads, spaces, transport, in the workplaces, in the public and private offices, And in educational institution, it is largely normalized, and the statement with that men with women and women should be careful. Terms used in everyday discourse, such as eve teasing and the cheer aim at trivializing the harm caused to women through the such acts and wrongly implies that the act of sexual harassment is fun and harmless. From a societal point of view, most women suffer from the sexual harassment in silence as there are adverse consequences faced by the woman who openly speak up against the perpetrator, who is often a male colleague or superior. Boys have often failed in taking the action against the perpetrator because they have not considered sexual harassment to be an issue that is serious enough to warrant intervention. It is a worst state of affairs when employers side with and shield the perpetrators and either transfer the complaining woman to the other office or discontinue her services as though she was at fault. The power dynamics at the workplace, lack of confidence in the organization that action will be taken upon the complaint, the stigma and strong social taboo associated with the harassment, the societal tendency of victim blaming, such as saying that the harassment must have taken place because the woman was not wearing appropriate clothes, or she was at the wrong place at the wrong time, or was giving the wrong signals through her body language. Peer peer pressure at the workplace that the woman may not get their promotion and increments if they speak up against the perpetrators and the woman's possible financial dependence on the job. Rupandal Bajaj worked as a special secretary finance as an IAS officer in 1998. Rupan and her husband went to a party hosted by then the Punjab Financial Commissioner S.L. Kapoor in Chandigarh, for which they had been invited at the party. The women invitees were seated in one semicircle and the male invitees in the another. As Rupan sat and conversed with the other woman, KPS Gill, the then Director General of Police Punjab, went and sat at a chair with the ladies. One by one, the woman left the place due to his misbehavior. He then called out to Rupan and asked her to sit with him as he had something to discuss with her. When she approached him as was about to sit, he pulled her chair close to his so that the chairs were touching each other. She sensed that something was not right and went back to sit with the other women friends. After some time, he approached the place where she was sitting, stood very close to her so that his legs were about 4 inches from her knees. He ordered her to get up immediately and go with him. All the women were shocked and speechless. Rupan objected to his behavior and asked him to go away from the place. When he repeated his command, Rupa tried to leave the place out of fear but was unable to do so as the KPS guard blocked her way. She pulled her chair back and got him and turned backwards to leave the place. He slapped her on her posterior in the presence of all the guests. This became a high-profile publicized case that was talked about for many years. Rupa informed her superior, including the chief secretary advisor to the governor and the governor of Punjab. After 11 days, when this did not result in the registration of an FIR with the police, Rupan formally lodged a police complaint. Uses influence and power as in the commissioner of police to stall the investigation. He approached the High Court and obtained an order quashing the complaint made against him. The trial court sentenced KPS Gill to a fine of 2 lakh, 3 months rigorous imprisonment. We have the Ruchika case also. She was lawn tennis association player. There was a CBI inquiry also. Banwari Devi was a Dalit woman who worked as a Satin, a grassroots worker employed by the Women's Development Project run by the government of Rajasthan. In discharge of her responsibility, in 1992, she stopped the village to village and prevent child marriages. In 1992, she stopped child marriage in Bateri. The upper caste men who were in favor of child marriage decided to teach a lesson in gang rape there. While the gang rape led to a criminal trial that resulted in the acquittal of accused persons. Balwai Davis rape was also called a flashpoint for the women's movement to demand protection from the employees for discharging their responsibilities at work. A non-governmental organization by name of the Vishaka filed a public interest litigation in the Supreme Court seeking guidelines in this regard. The guidelines issued by the Supreme Court judgment in the Vishaka versus State of the Rajasthan 1997, the Supreme Court of India passed a landmark judgment observing that sexual harassment at the workplace is a violation of women's fundamental right to pursue a trade, occupation, or profession of her choice as guaranteed by the Indian Constitution. This is because she is deprived of a safe working environment. The Supreme Court also emphasized that right to life means right to life with dignity. The primary responsibility for ensuring such safety and dignity was through a suitable legislation by the legislature and the creation of a mechanism for its enforcement. However, as a stopgap arrangement till such a law was passed by the legislature, the guideline laid down the employer's responsibility for taking due to such prevents the redress grievances of the sexual harassment by establishing a sexual harassment complaint committee. Sexual harassment was criminalized in 2013 and spelled out as a punishable offense. The Indian Penal Code includes sexual offences in the public spaces as well as private spaces. The sexual harassment of women at workplace. 16 years after the Vishaka judgment was pronounced in 2013, the Sexual Harassment of Women at Workplace Act was passed. It has been enacted with the stated objective of the providing protection against sexual harassment of women at workplace and prevention and the redressal of complaints of sexual harassment and related matters. This is a civil law that lays down measures to prevent and prohibit sexual harassment in the workplace and to provide redress of complaints. It provides for the establishment of the complaints committees to investigate and redress grievances. Both the IPC provision as well as the 2013 Act consider women to be the victim and the man to be perpetrator. After the enactment of the 2013 law, the Vishaka guidelines are no longer operational. Though, with the IPC provision as well as the 2013 Act consider women to be the victim and the man to be perpetrator. It also enacted civil legislation, women at the workplace in 2013. The Parliament insert